Hello and welcome to the meeting of the Consumer Debt and General Civil Subcommittee of the California Paraprofessional Program Working Group. I'd like to begin by taking roll. Brynolfson?
Present.
Fleischman?
Here.
Hamilton?
Present.
Hartston?
Here.
Robinson? And I believe she said she's not available to be at the meeting today. Shining?
Here.
And Judge Yu?
Good morning, I'm here. Thanks for the extra 30 minutes today.
Challenging meeting to put together, and thank you, Abbas, for stepping in.
Oh, my pleasure. Thanks for having me.
All right, so I think we should go to public comment, Carolyn. If that works for you.
Do we have folks? And we probably have a little extra time, Leah, maybe? 1 to 2 minutes.
There's already a hand up in the public comments.
I'll go ahead. So Stephanie Carroll.
Hi, thank you. Can everyone hear me?
Yes.
Great, thank you. And I don't think I'll need more than a couple of minutes. I just wanted to touch on certain areas. I haven't been able to be listening in at these meetings, so I've been relying on notes from colleagues, but there are a few areas that seem to have come up recently that I would like to comment on. The first one relates to affirmative debt claims, and I'm glad to see that Abbas is here, and I'm sure he'll be talking about that. I'm a bit sad that Justice Petru isn't here, because as I understand it, Justice Petru has expressed concerns about the number of unrepresented debtors in their court. But one of the things that I want to say is that what was clear from the Justice Gap study, and I think there are lots of problems with it, but one of the things that did come through loud and clear is that the biggest problem for many people is that they don't understand that an attorney can help them. And that is one of the biggest gaps that was presented. If people have affirmative debt collection claims, for example, if they're being harassed by creditors, they have a case that a private attorney will take on a no-win, no-fee basis. Those cases are different from debt defense cases where someone has no affirmative defenses at all. But if they have affirmative claims, there is a thriving private attorney bar that will take those cases and remove to federal court as appropriate. I next want to move on to the enforcement of judgment, which seems to be something that's still on the list. And I think, in terms of enforcement, where companies are transparent and willing to pay, there's no issue. It's always the very kind of tricky defendants that are hard to track down. And that process can be fairly complicated. It can require debtors' exams, similar to depositions really, about assets and their location, arguments about corporate alter ego and piercing the corporate veil. And if the committee is thinking of going down that route, what I would say is please make sure there can be no upfront fees and that payment is limited to a set percentage of money actually collected. Now, there are agencies out there that already do this and they charge a very high percentage for recovery. So I would suggest that a much lower percentage will be set, because otherwise you're just replicating a system that already exists. Very briefly on wage garnishment, I see there was some discussion about whether wage garnishment should be moved to the Employment Committee. As far as I can see, that is very much a consumer issue and should stay under the purview of this committee. And then finally, I see that utility shut-off is still an area for review. Now, it is my understanding from various of these meetings, and I think legal services attorneys have made clear as well, the role of paraprofessionals, I think, from your point of view, should be limited to those people who cannot gain access to legal services. It's the people in the slice who cannot afford to pay up by an attorney, but who also cannot access legal services. So I don't understand what the role of paraprofessionals and utility shut-off really could do, because clearly we're talking about very, very low income folks at that point. I would advise getting somebody in from the Public Utilities Commission to comment on that and to comment on utility shut-off and the strategies for avoiding it, and to ask them whether they see a role for a for-profit paraprofessional in that space where people generally have absolutely no money at all, which is why they can't pay their utilities. So I'll limit my public comments to that at this point. I and other colleagues will be commenting at the full Paraprofessionals Working Group meeting in a couple of weeks. Thank you very much for your time.
Thank you, Stephanie. Okay, so I think we have, do we have two presenters, Leah? There was a judge who was going to come.
We do, and I don't think we have any more public comment. So if I could share my screen, I will talk about today. So I wanted to just lay out today's meeting and then the meeting that we have in 2 weeks. We did start this meeting late because it was difficult to find matter experts to come today. We are going to hear from Abbas Kazarunian, who you all did hear from, I think that was about 7 or 8 months ago. And will be joined at noon by Judge Noel Weiss with the Alameda County Superior Court. And the focus for today, my hope is the focus is going to be on representation in debt collection matters and creditor harassment. You can see on the screen here who is slated to attend so far on the 25th, where we will add on to our agenda judgment enforcement. And relevant to the comments that the speaker just made, we are going to hear from someone with a private judgment enforcement agency, mostly non-lawyers doing judgment enforcement work. So I think that will be interesting. What I wanted to share in this next couple of slides before we turn it over to Abbas is sort of where I think we are with each of these topics and what issues I believe have been identified so far and what we need to do. I did this week spend time listening to all of the webinars from the meetings last year. So I was able to kind of understand that though we've had a lot of discussion, particularly about representation of debtors, these first two, we really haven't made much progress in actually understanding what the work involved is. And I think it's because people are very passionate about whether or not it's appropriate for a non-lawyer to do the work. And there are often a lot of examples of very sort of egregious or complex situations that come up in our discussions, but that's precluded us from actually just getting to the nuts and bolts of what the work is. So I'm hopeful, Abbas, in particular, that you can help in those first two, like what are the actions that you take when you represent someone in these situations. I've identified some of the issues that I think came up again from listening to the webinars, really wanting to dig into the possibility of and the likelihood of affirmative counterclaims within that defense. An issue that also was raised had to do with settling a debt in a manner that does not impact government benefits. And I'm not sure that applies here or actually in enforcement of judgment. So that might be in the wrong place, sorry. On creditor harassment, a big issue around the federal court jurisdiction versus state court jurisdiction and understanding the differences in the remedies available there. And lastly, I wanted to share that I was able to really build out wage garnishment. We're not going to talk about it today, but I was able to do that. So I think we have a good handle on the activities there. And as I suggested at our last meeting, I will try to work offline with the subject matter expert that we heard from on this topic to finalize the activities list so that when this comes back to you, you have a fully fleshed out list of tasks with some perhaps recommendations about what might be appropriate for a paraprofessional to do. So those are my slides for today. And with that, I will turn it over to Abbas. I will just also briefly mention that I did also spend time looking at federal court filings data. So to the extent that I'm able to understand that, if that is something of interest to this subcommittee, we can take a look at volume of filings that might be relevant to the topics that we're discussing. particularly these first two, because I think it's helpful to have that conversation informed by data and a sense of the volume of the filings. Judge Yu.
I just wanted to take a moment to thank you, Leah. That's true dedication to go and listen to all those tapes all over again. That's really impressive. Thank you.
Oh, sure. Steve?
Yes, thank you, Leah. I would like to hear the data about filings in federal court because I do think that has a significant bearing on the creditor harassment issue because paraprofessionals can't be in federal court.
Okay, so maybe we'll start with Abbas and then we will plug in the filings data as it seems to make sense in the conversation, if that's okay with everybody. All right, so Abbas, if you could walk us through really these first two and the work that's involved. And again, thank you for agreeing to step in today.
No, I appreciate it. Thank you very much. And I appreciate the distinguished panel here. I'm willing to listen to what I have to say. So this is actually a pretty, I know we've kind of categorized debt collection, defense, and creditor harassment, the FDCPA versus RFDCPA is two categories. But I want to start with laying out the preface that these are very much intertwined and they should be kind of looked at with the same lens, though I will try and separate them and deal with them separately. But there is a lot of overlap, as you will see through my presentation today. So starting with debt defense, I think it's very, very important to understand where the paraprofessionals are coming from, because it is undoubtedly the #1 area, not just in California, but throughout the country, of lawsuits that clog up our court system. The credit card defense, medical debt lawsuits, we're talking thousands a week. And I think, Judge, you'll probably attest to that. It is the #1 issue across the court system clogs. Now, the important aspect here is that we understand that this is black letter law in the Ninth Circuit deemed debt collection activity. If it's a consumer debt, which the vast majority of these credit card debt collections are, under a case called McCulloch versus Johnson, Rodenberg, and Lorniger, which is the seminal case on this issue, there is no litigation privilege when you're a law firm doing debt collection in this arena, which separates it to other areas of law, which means that they are under the purview of the FDCPA and to a certain degree, the RFDCPA. So it is definitively debt collection activity, meaning the pleadings, the discovery that they send to pro se clients or otherwise are debt collection activity. So it's important to work from that foundational standpoint to know that every pleading that is served on a consumer, even though it is litigation activity, is under the purview and actionable potentially under the FDCPA. Now, let's take it to the next step. This is definitively a debt collection industry. And I think it's really important to understand the debt collection industry before you delve into whether this is appropriate for debt collection or paraprofessionals to be assisting consumers with. So as we already discussed, it's the #1 litigated issue in all the dockets around the country. Now, most of the law firms that exclusively do this area of debt collection, I'll give you, so for example, Amex has an exclusivity contract with a firm called Michael & Associates. And a lot of these big or portfolio recovery users, Hunton and Enriquez in California, they use specific law firms that do this exclusively for big debt collectors, debt buyers, and original creditors. But realistically, these people are filing thousands of lawsuits per month. But if you actually look at their law firms, they only consist of 2-3 lawyers in their establishment, because the rationale here is that they are 100% relying on the fact that the consumers are going to default 99% of the time. And I'm not just saying 99 just because I'm making that up. That is an actual statistic. 99% of credit card lawsuits are defaulted. And I think it's I I think that is probably why the paraprofessional community wants to get involved, because they're like saying, you know, it's access to justice. But the reality of the situation is, I think it's a lack of information. Why? Because I personally, my law firm represents probably we're retained on about 50 of these lawsuits a week. So we're talking approximately 200 of these cases a month. And these people obviously can't be paying $300-400 an hour, otherwise they'd pay the credit card lawsuit. And the reason why they retain my law firm is because we do a very, very small flat fee for these debt defense cases, and that takes it all the way through trial. But more importantly, if we can identify a counterclaim, we then do not charge the consumer any money for the defense of that case, because we know that we're going to get that back in a contingency case under the FDCPA, the Rosenthal Act, the TCPA, the FCRA, the CCCIAA, and a plethora of consumer statutes that our lawyers are educated on. And I think this is where the rubber meets the road, which is a paraprofessional can potentially defend one of these cases, because it's not going to be rocket science litigation here, but they will be going through the motions without really knowing how to litigate. And the reason for this is we actually take a lot of these to trial and win, especially on the third-party debt buyer cases. And I think Judge Yu can attest for this. So when you say you have someone like Midland Funding, Portfolio Recovery Associates, they're third-party debt buyers. And we go through rigorous discovery with these guys. We send them bill of particulars, we send them requests for documents, we send them interrogatories and form interrogatories. But we hone in on specific documents that we are educated on because we know the debt collection industry. For example, one of the things that I personally concentrate on getting are what's called the forward flow agreements, which are the master agreements between the original creditors and the debt buyers, and they never want to produce those. So we have to go through meet and confer process, motion to compel, and then if we are able to obtain that through the discovery process, sometimes we're able to get sanctions in that process, which means that if those go to the lawyers, which if we get a substantial amount of sanctions, I give our fees back to the client, because I don't want to charge them for anything else. Because if we've gone through that process, the chances are at that point we're going to be able to find a counterclaim. An example of this is, for example, I've found forward flow agreements where the original creditors have told the debt buyers that they will not produce more than 50% of the notes on the 10,000 notes that they've sold to the debt buyer. Meaning that, let's say an original creditor sells 10,000 accounts or charged off debts to a third party. What they're saying in that contract is, we are not going to, if you sue on 100% of these, which they usually do, we're not, and all of these are litigated, we're not going to produce the documents to you in discovery for more than 50% of those. Now, the third party is going to rely on the 99% default rate and go and sue on 100% of those, knowing that 99% are going to default, and the 1% that litigate are going, and they're going to be able to get the notes from the original creditor. Because essentially, when you have a sale of these notes, it's really an Excel sheet with a bunch of account numbers and the balances that's going to the third party. They're not actually getting the bills, they're not getting the proof that they need to be able to substantiate the debt. And when I got that, that automatically means it's a class action under the FDCPA and potentially the RFDCPA for that conduct, because they're suing knowing that they can't prove all the debt on all 100% of the accounts if it's taken to task. They're working on an assumption. Now, let's move one step forward. Let's say we get through this process and on a third party, you get to trial. I suggest some of my clients may want to settle, but a lot of them that have nothing to lose, and I'm saying, listen, we have a good shot at trial. Why? Because by the time the note gets to trial with a third party debt buyer, the note has passed hands at least 3 times on average when you look at all the third parties that are bringing these. So that means the original creditor has sold it to debt buyer number 1, then it's sold to debt buyer number 2, and then it's sold to debt buyer number 3 who brings the action. Now, you need an intricate understanding of the civil rules of procedure, because most of these debt buyers are going to try and testify through declaration, because they can in limited jurisdiction, because the average amount of debt in these credit card lawsuits is approximately $3,500. And what I immediately do is I immediately issue a subpoena because I want the custodian of record to show up and testify at trial. But I also know that the chances are very, very strongly in my favor with a third party, that if the rules of evidence are being strictly adhered to, they're not going to be able to prove the case. Why? Because ABC debt collector, who is fourth in line in the chain of custody, is going to show up with on their best day with their custodian of record. And they're going to try and put in the evidence, their credit card documents from the original creditor. And I'm going to be screaming objection, hearsay, lacks foundation. And the judge is going to probably sustain that objection because there's 3 levels of hearsay that they can't prove up the chain of custody. Now, my question is, can a paraprofessional really understand the rules of evidence and civil procedure in order to be able to go through this, really do the intricate discovery that they really need to be able to find counterclaims in the process? And if so, take the trial and have very, very good success, at least against third parties. Against the original creditor, I concede it's a little bit more difficult. But we have mechanisms in discovery that are available to us because we paper the original creditors. The way that these companies are structured, is that, like I said, you have 3-4 attorneys and a bunch of paralegals and secretaries that are processing thousands of lawsuits, predominantly because they're filling in forms to get default judgments and sell them. But if they are papered, they are not designed to deal with the responses to assist consumers in going through the litigation process to really be able to prove up the cases. Now, if original creditors and third parties know that certain law firms, when they are defending these consumers, will take it to trial, I have about 20% of my cases are dismissed as soon as I get involved because they don't want to deal with me because I'm a pain. Because I know the system, I know the rules of civil procedure, I know the rules of evidence, and guess what? My firm will take it to trial because these are 3-hour bench trials and my first-year associates all need trial experience. They love doing this. That I train them personally on how to try these cases, and they cherish at the thought that they can help people and get trial experience at the same time, and yet the consumer is only paying a small flat fee on their worst day. Now,
Abbas, can I ask, so some cases have the counter claims or affirmative claims, right? And some don't.
Yep.
So when you just get it, can you just describe, a client comes into you, is there an initial assessment that's done to determine if there's any sort of affirmative defense or counterclaim or anything there other than a straight run-of-the-mill case? Or do you always have to go through this discovery process? Do you do that in every single case in order to determine if there's something there? Like, can you?
Absolutely. You actually asked that question exactly at the wrong time and the right time, because that was my transition. Because I was going to say about 25 to 30% of my cases have a counterclaim on the screening process when they come in. And when they come in, we do an intense screening process with the consumers to see how the debt collectors, which includes the law firm, not just the creditor that's trying to sue on it, okay? Because you have 2 potential defendants to go after here, and maybe 3 with the bureaus if you go into the Fair Credit Reporting Act issues. So we do an intense screening process at the intake process where we're looking at how and if the consumer was actually served. What's in the pleadings? The pleadings themselves may be a source for lawsuits. And I'm not making that up. An example of that is Heathman versus Portfolio Recovery, Southern District of California, which ultimately became a class action and it settled. But this happens on a regular basis. So we look at the telephone calls that they got that led up to the lawsuit. We look at how the methods of telephone communication, were there any cease and desist communications? Now, once we're also retained, a lot of the time, the debt collection firms don't process our representation, and they continue to send CMC statements to the consumers directly, which is contacting a represented party, which is a per se violation of the FDCPA and the RFDCPA. But going back to your question, Leah, on the screening process, we're also asking the consumers to pull their credit reports to show whether the reporting is being done accurately, which triggers two potential other statutes, which is the Fair Credit Reporting Act and the CCCIAA, which is the California Consumer Credit Reporting Agencies Act.
Abbas, could I ask you to clarify something?
Yes.
Leah used the phrase counterclaim.
Yeah.
I want to understand, are you meaning that in the technical procedural sense of a counterclaim, or are you also using it to refer to filing affirmatively, the best defense is a good offense?
I'm actually talking affirmative actions against the debt collectors. And what's very interesting about this is—
Thank you.
Of course, I hope I answered that question.
No, go ahead. I didn't mean to interrupt.
But further,
We also have Judge Yu with her hand up. I don't know if this is related, Judge Yu, if you want to jump in now or let Abbas answer.
Sorry, I couldn't see that. I wasn't looking for the hand. Sorry, Judge Yu.
Oh, that's all right. Thank you, Carolyn. Thanks, Abbas. You know, I'm remembering how great it was to have you before and how much I learned from you. And you're absolutely right. We would get stacks and stacks of default judgments when I was in civil. All of us parsed out, and they're pretty much all credit card claims. I have questions, but I would ask you to please finish answering. And whenever it's a good time for me to jump in, let me know and I can ask questions. I don't want to interrupt your presentation.
I appreciate that, Judge. I'll finish my thought and then I'll come back to address your questions. Thank you so much. And so one of the issues is that you were that I think was on the outline of the agenda, and I think it's kind of been alluded to, is state counterclaims versus federal counterclaims. And so to the degree possible, where you find a federal cause of action, for example, the FDCPA, it is not a compulsory counterclaim in state court, because there is some of my own opinions in federal court that have showed that the method of debt collection is a separate issue, separate and apart from the actual amount alleged that's owed by the consumer. So I have the authority to go file that in federal court. And the reason why I do that is because if there are cross actions with attorney's fees, because a lot of the time the credit card attorneys are also asking for attorney's fees on their cause of action. And so what you don't want to happen is a wash. You want to get leverage for the consumer by filing the counterclaim in federal court in an ideal situation, because those two are separate and apart at that point. Because even if they get a judgment against the consumer, that doesn't give them an offset on the federal lawsuit if they owe attorney's fees on the federal claims, which predominantly, or apart from the TCPA, all have attorney's fees provisions like the FCRA and the FDCPA. And so we are screening, and to the degree possible, we file a high amount of cases in federal courts, and you can actually create a lot of leverage where the debt is usually forgiven, and though that's not a guarantee or a remedy under the statute, though conventionally that's something that's offered because it doesn't cost the creditor very much, maybe a little bit of cash in the consumer's pocket, and then attorney's fees outside, which then alleviates the consumer from having paid me in defending their credit card lawsuit, and in fact I get paid by the creditor. That happens 25 to 30% of the time on our screening process, because I think it's short-sighted to just look at the FDCPA, even though that is the predominant counterclaim that we would have in federal court, or if it's only a Rosenthal case, you would have it in state court. But that's going to happen in rare occasions, where the case is only against the original creditor and not the law firm that is bringing the lawsuit. Whereas most of the time, the lawsuits at this juncture are going to be against the law firm, which is going to bring about an FDCPA case, which means that you can go to federal court. But it's important to screen properly, look at TCPA, FCRA, CCCIAA, the California Penal Code 632. Even though it is a penal code, the call recording statute has a civil element with actually staggering damages, $5,000 per call because we're in a two-party state. And those also bring about phenomenal class actions with them. And so when you get a sophisticated consumer attorney you can actually massage these cases in a very, very sophisticated way where the consumer is a lot of the time walking away with money in their pocket, not actually paying the attorney. And I think it's important to understand that dynamic. And when I talked at the beginning about the overlap between these statutes and debt collection, because they are part of the same parcel, this is where that overlap comes in. Because if you come in to defend one of these cases in a vacuum without any cognizance of these ancillary statutes that can be weaponized in favor of the consumer in order to assist them, I think you're not doing the consumer justice, because these are rights that they have that should be vindicated in the appropriate circumstances. And I think, like, you can probably help 40–50% of consumers with these statutes where they're not paying anything out of pocket. Then you can add another 10–20% where you may be able to find counterclaims or causes of action in litigation. And then you can help others eradicate the debt, especially against third-party debt buyers at actual trial stage, where you need proper trial experience and legal knowledge, specifically in evidence and civil procedure. So I think that's the counterplay. Now, I think the other category under the debt harassment, Leah, I think the issues of RFDCPA and FDCPA, for the most part, not always, for the most part, where you have an FDCPA case, you also have an RFDCPA case, but not necessarily the other way around. If you have an
boss, this is a good time because we now have two committee members with their hands up. So I would, okay, so let's go to Judge Yu and then Amos.
Absolutely.
Okay.
Thanks, Abbas. You know, I'm thinking your job is so interesting, the way you say it, and I appreciate your passion and energy for it. It's just great to hear from you. And what you're saying really resonates with me, because when I got those piles and piles of default judgment files that I had to look through, it's interesting because I noticed there wasn't uniformity in how the presentation was made by the creditor. Sometimes, you know, all the bills are there and the application is there, and sometimes there's nothing except for just a declaration. And I would say, well, where's the document? So now I understand why some of those applications come in with no supporting documents. So my question is really more toward what I'm wondering about for this program. So I have basically two types of questions. The first is, I found it interesting that you said you were able to train your first-year associates. And for this program, if the state bar does decide to adopt it, the thought process is that the potential paraprofessionals would be coming from the group of people who have gone to law school, but who didn't score 390 on the bar exam, so maybe didn't pass, or currently paralegals who would like to expand their expertise and practice area. So and then there's also quite a bit of education, practical hours, and testing that would be required for someone to be licensed. For example, 1,000 hours of work experience. Do you think that someone who maybe did not pass the bar, who's maybe, you know, under a first-year associate, maybe you have paralegals in your office, for example, do you think those people could be trained to handle, perhaps not all the way to the, you know, trial, but the basics in terms of representing consumers?
I think there are certain elements of it. I think it would be disingenuous of me to say they can't. I think there are certain elements of it that they can. However, that has a massive caveat to it. And the massive caveat is the overlap that I was talking about, Judge, in the regard that if we can, like, because what we can do is offset the pay, because imagine you have a paraprofessional that is doing these basic jobs that you have laid out, and they begin to do them correctly. And then the first question I have is, do they have the knowledge about the federal law as far as the FDCPA, the TCPA, all these other ancillary statutes go, in order to be able to continuously and systematically be screening for those in case that overlap ever comes about? And then my question is, you see, when we're doing it in-house as a law firm, I'm in a position to say, well, you don't need to pay me anymore. Your $800 that you paid us to take this to trial, I don't need to take that anymore. It's in my trust account, because I can now go and get it on my attorney's fees from the FDCPA. My question is, how can the paraprofessional give that service and offer to a consumer where they can go and get their fees from the consumer, because once you go into federal court, they're out of the picture at that point, right? And so you don't have that flexibility to be able to neutralize what the consumer is having to be out of pocket about, because obviously the paraprofessionals need to be paid for their services, and I'm not suggesting otherwise, but they don't have the ability as attorneys to be able to go and say, you know what, I'm going to give you your money back now, because if you had a counterclaim at the beginning, I wouldn't have taken it. I would have just taken it from the consumer statute, which now has arisen. But the paraprofessional doesn't have that ability, and I think that's where they're going to have a lot of difficulty outside of the fact, on a financial level, outside of the fact that I don't think they're going to be able to do the cross-referencing and the screening as the case progresses. So I think those are the two issues I would have with it.
Thank you, Abbas. So did I hear you say that when you said you charge a small fee, is your fee at $800? It takes people all the way to trial?
Yep.
Okay. So then my last area of questioning is really about, can you please remind me, where is your law firm?
Yes, we're a multi-jurisdictional law firm. We're in six states, but in California, we're in San Diego and Orange County and San Luis Obispo.
Okay, thank you. So, we're learning that there are areas in the state which don't have really the resources that large jurisdictions like San Diego and Orange would have. There's Trinity, there's Tulare, there's other parts of the state where people can't access the quality of representation they might have from you. And are you aware of there any other firms that practice in California that do serve jurisdictions that are smaller or people have less access to representation?
Yeah, I personally, my law firm represents clients in this area across the state. Like when I say we get retained on 50 cases a week, approximately. It's between 40 and 60, so I'm saying 50. It's from all the counties, because we advertise in all counties in the state of California. And like people that do it on a statewide level the way I do, I'm aware of about 4 or 5 other law firms that do it on a statewide level. And then of course there are smaller practitioners that do it in their more discrete regions, and that obviously there's more in LA County than there are in, let's say, Merced County. But there are a lot of practitioners that do it geographically and like in their specific areas, and then there's 4 or 5 that do it statewide, like myself.
Yeah, Abbas, you just
follow-up question, Abbas, which is there a specific, a specialty bar association where people who practice in your area are members, so that we could tap into it and map out perhaps where people are being represented and where they're not? Sure.
It's called NACA, National Association for Consumer Advocates. But I'm also aware of people that are not members of NACA, and also NCLC, National Consumer Law Center. So those are the 2 major organizations that people are part of. But like I also think I think the real problem here is the 99% default rate, right? Like, and what's coming about on that. I think it's a myriad of a lot of reasons, Judge. Number one, we have a national epidemic of sewer service, which is a problem. Like people are not getting served that they should be. I'm not saying all 99% are not getting served. A large portion are getting served. But even if you say 10% of those people are not getting proper service as is required by the California Constitution, I think you have a problem. And then I think you have a major problem in the fact that people don't know that they have quality legal representation available for them for a low flat fee, or if they actually went and consulted for free with every attorney in this field offers free consultation, and whether they have counterclaims and they can get free legal representation. And then you've got just basically lack of education, and where people just basically put their head in the sand and don't want to deal with it and just throw whatever they're being served in the bin. And I think there is a small percentage that may have tried, and some attorney have said, you know what, you have to pay us $250 an hour or whatever it may be. But I think there is a serious educational issue, and I think issue with sewer service and the fact that people don't know that they have rights. That is also at the forefront of this problem. and whether that's with a paraprofessional or a lawyer, it's important that the consumers know about it. Because let's even hypothetically say I endorse.
I'm
sorry?
sorry to interrupt. I just want to thank you because I feel like I've consumed too much time with my
Of
questions.
course.
I'm
I was
sorry.
just gonna say, Amos has been,
Yeah, we have Amos,
this has been really patient.
and Carolyn. So why don't we go to Amos?
Thank you. Thank you so much.
Thank you. And a lot of my questions actually overlap with yours, Judge Yu. So I'll try to be streamlined. I also want to really thank you for coming and talking a lot of really helpful information that also rings true for me. So I'm in the consumer protection section of the Attorney General's office and follow some of these consumer protection statutes. I assume you've been following what the CFPB has been trying to do in this area about the debt collection industry and some of these transfers you're talking about and documentation and sewer service and all these problems are a real problem. And I also agree that it's a huge part of the court docket, and a significant number are default prove-ups, both in small claims court, in limited jurisdiction courts. It's a big part. And the 99% default rate, I think the point of that you and Stephanie in public comments make about an education issue is a real one. I'm interested, you say you have intensive screening of your cases. Who is doing that screening? Are those paralegals? Are those younger attorneys? Are those sophisticated attorneys doing that initial screening in your cases?
So I mean, and again, this is like, there's no formula to this, but of course, this is my formula for my law firm. I have an intake department, which is headed up by a more senior lawyer, and the junior attorneys are working in conjunction with paralegals. So paralegals ask for certain documents, but the people that are actually looking at the documents and making determinations of whether we believe we have legal causes of action to take forward are conducted by lawyers, which is also head. I have a head of intake, who is also a fairly experienced lawyer. I mean, I can't say he's like a 20-year lawyer, but he's a 7-year lawyer. So it's fairly in depth.
So it's very clear to me that consumers would be better off if they had sophisticated consumer attorney like you, your law firm, like some of the legal services that may be available if they qualify for free attorneys. People are definitely better off with sophisticated consumer counsel. But what about the people who for whatever reason aren't your clients and aren't getting free lawyers? Are they better off without legal assistance, or are they better off with somebody who is trained and licensed and can maybe assist in reducing the default rate and getting settlements, maybe with some defenses, and maybe not federal cases or class actions? That's certainly leverage that they would have if they went potentially, if they had a consumer attorney, and agree they'd be better off if they potentially had that leverage in the 25 or 30% of cases. But what about for the other, vast majority of these default cases throughout the state? What do you think? Are they better off without any kind of legal assistance, or would they be better off with somebody who is trained and licensed and could potentially identify some of these issues and refer them to an attorney, or at least defend them and avoid the default judgment?
Thank you very much for the question. But I don't think the answer is binary. In that you either have no legal representation or a paraprofessional. So for example, when a consumer comes to me and says, I can't afford your $800, I'm like, well, can you explain to me why and give me the situation that you're in? And sometimes we reduce our rate to 500 and as low as 400. Now that's a rarity if it's a single mother and she's just lost her job or whatever. And like, I will make exceptions if I think that, and sometimes like we even do pro bono, but yes. So, but the standard price is $800. My question is, how much is the paraprofessional charging? Because like I'm charging $800 and I even do payment plans because especially post-pandemic, you're not going to get to trial in less than 3 years. So I'm just saying, pay me $50 a month and we'll take your case. Can a paraprofessional match that? And my question is, how much are they charging? Because you're asking me to make a comparison without me knowing one part of the equation, which is what are they charging?
I very much appreciate you raising that, because that is one of my concerns that I have been raising. In this area and also in housing, there are flat fee attorney services available. And the concern is if there's no restrictions on what a paraprofessional can charge, paraprofessional may end up charging higher rates than attorneys. And I think this is a serious concern. So yeah, I think we would need to address that issue. And if this is really supposed to be a lower cost alternative than hiring an attorney, there needs to be some, I think personally, but this is still an open issue with the working group. But yes, I think assuming the same cost or less, and I can't guarantee that's what's going to be proposed, but that is something that I'm focused on. Assuming the same cost or less, but they wouldn't be attorneys, so they would have some limitations. They wouldn't be able to do class actions, I'm again assuming, wouldn't be able to go into federal court. They would be able to refer cases if they identified those issues.
Sure.
But with that assumption that it would be, you know, the same cost or less for fees.
Okay, well, if it's the same cost, my question is, why would you go to a paraprofessional when you can have a lawyer? And the lawyer obviously has the knowledge of other areas of law that the paraprofessional may not. And if you don't have a counterclaim at the beginning, but finds one through litigation, will give you your money back.
Yes. So, okay. Can I ask you one last question about attorney's fees? So when you are talking about recovery of attorney's fees, you're talking about statutory attorney's fees, right? Do you take the cases on a contingency basis, or do you take them for free, assuming you may recover attorney's fees at the end?
So I take, like, you're talking about the counterclaims that I may file, like, affirmatively in federal or state court, right? So I take them on a contingency basis with a guarantee that if we lose, the client pays nothing. So,
and then you also seek attorney's fees under the statute, is that right?
yes, yeah, that's exactly what I do, because most of these statutes have attorney's fees provision. The only two that I have mentioned that do not are the California Penal Code 632, which have $5,000 statutory damages per call or per violation, and the TCPA, which have $500 statutory damages for negligent violations and $1,500 per violation for willful violations. So you don't need that many calls to stack up damages in either of those statutes. The remainder that I have mentioned, like the FCRA, CCC, RAA, RFDCPA, CETA, for example, California Identity Theft Act, that is a phenomenal statute that we use on a regular and systematic basis, have attorney's fees. Vast majority have attorney's fees.
And one last question, and I really appreciate your time, very, very helpful. You said you have a preference, at least in some cases, for filing in federal court instead of state court, sort of for more leverage. Are there any claims other than class actions that you bring in federal court that couldn't be brought in state court?
I'm sorry, can you say that again?
Are there any claims that you take, whether they're affirmative claims or counterclaims, that you bring other than class action cases that you have elected in some cases to bring them in federal court for leverage reasons? Yeah. But are there any of those cases that couldn't be brought in state, any of those claims that couldn't be brought in state court?
Yes, systematically, we bring individual cases in federal or state court, just individually, not a class action. And in fact, like a good example of this is a case that's been to the Ninth Circuit 3 times on a very, very simple debt buyer case brought by a firm called Anaya Law Group versus my client, Afewerki. Mr. Afewerki. I
am going to interrupt you because we have other hands up and we have another speaker coming. I think what Amos was asking is there any case that you couldn't bring in state court other than a class action? Not that you might choose to bring it in federal court or state court, but that you would be precluded from bringing it in state court. That's what he was asking.
No, and you can, and just for your edification, you can bring class actions in state court. But yes, I'm not aware of any cases that you can't bring.
Thank you so much. Very, very helpful.
Right, so let's go to Steve and then Greg. Steve?
Just to follow up on that last point, any action you file in state court under a federal statute is subject to removal, correct?
Yes, sir.
Okay, so this is getting to what I've been struggling with, which is we have an opinion from the State Bar's General Counsel that paraprofessionals, in essence, will not be allowed to practice in federal court. I'm paraphrasing. time and time again, you've referred to federal statutes, which if you sue under affirmatively, either you lose the option to go to federal court in the first place or could get removed. Now, I understand if it is a true counterclaim, that may not be removable in that circumstance. But it seems to me if we allow paraprofessionals to litigate this myriad of claims, they are going to be at a significant disadvantage. Tell me I'm right, tell me I'm wrong.
You're absolutely right. And in fact, if you, I mean, obviously state courts have general jurisdiction to hear federal causes of action, but 95, 98% of the time you file a federal cause of action in state court, you're getting.
So
Can I
then,
ask a follow-up question though on that? Have you, in your vast experience, have you ever seen a creditor remove a debt collection case from, or consumer debt case from state court to federal court?
A collection case, no.
Yeah, technically, I think that is a technical possibility, but have you ever heard of a creditor preferring to be in federal court, or a creditor removing a claim from state court to federal court?
No, but if you sue the creditor or the debt collector under a federal cause of action in state court, they systematically remove you to federal court.
that's my understanding, and I'm hoping to hear from Leah about the court statistics. So my follow-up question is, tell me what you think about this system. And if it's a good idea, the credit goes to Amos. If it's a bad idea, blame me. But allowing paraprofessionals to represent debtors in what I'll call the true debt collection case with the 99% of defaults. But if it turns out that they have an affirmative claim, whether a true affirmative claim or a counterclaim, however it is, that at that point they need to hand it off to an attorney. That's the model that's used in Washington. By the way, there are no referral fees allowed in Washington. We're struggling with that issue. But tell me, is that a good compromise? Is that a bad compromise? Tell me your thoughts.
I mean, I go back to my responses to Judge Yu and Amos, which is it's one question in my response and two other factors to consider. Number one is, how much is the paraprofessional charging? Because if it's a similar amount to what I'm charging, my question is, why would you use a paraprofessional when you can have an attorney that's been practicing for 15 years in this specific field?
I agree with you. I agree with you, but there's a perception among some, and I don't share that view, that there are not enough of you in the community. I don't share that view. Okay. I'm just telling you what other people think.
Well, I can tell you, I have never turned down a consumer that has come and said, I'd like to retain you because we're too busy. Like, I have never done that.
Thank you.
Let's go to Greg, because we have about 12 minutes, and then I think we have we have another judge coming in.
Karen, can I just finish quickly my response to Mr. Fleischman, which is, and the other thing is, it's even going arguendo to your point that, why not give it to a paraprofessional who can refer it? You're making the assumption that the paraprofessional can issue spot these counterclaims when and if they come about. And then thirdly, on an economic level, if they do, are they going to give their money back for the work they've done up to that point before they refer it over, which is something that I would do. So on all those 3 points, I think I would have to say that it's not a good thing to give it to paraprofessionals, because economically and legally, you're in better hands by being with a lawyer.
Thank you.
So, Craig.
Hi, boss. I'm Greg Fortescue. I'm a lead attorney at the California Supreme Court. And you actually just answered one of my questions, because one of the questions I had was, under what circumstances do you turn away clients who can pay $800? You answered that you've never turned away anyone. I'm hopeful that everyone that practices in your area has the same ethic when they come to selecting clients. I'm not sure that's entirely true, just because of the numbers of self-represented debtors that we're seeing in our court system right now. And I do agree that there is a huge education problem here, that we need to educate consumers and hopefully entice more lawyers to do the kind of work that you're doing right now. But my follow-up question for you, I guess, is if this program were designed, especially in this particular area, to allow paraprofessionals to work under the supervision of a lawyer like you, and they were well trained in this area, would those be the type of professionals that you'd be interested in hiring?
Yeah, I mean, absolutely. I have a bunch of paralegals in my law firm that I employ, and they're under my supervision. And because we're under the umbrella of a law firm, that gives us much more flexibility to be able to help consumers in a plethora of different ways, that if you are a one-man shop or a two-man shop or whatever it may be, as a paralegal company, that you don't have that ability. So yes, I think that would help, but essentially you're becoming a paralegal in a law firm. You're not running your own shop as an independent body.
Understood. I think the way we're envisioning these paraprofessionals is they would have a greater breadth of authority to practice law. And in this case, what I'm proposing, just hypothetically, I'm not advocating for this, it would be under the supervision of a lawyer. But it occurs to me that perhaps not every firm is following the same standard as you and taking every comer, every client that's coming in. And it may be also a problem of capacity in the state, a capacity for law firms being able to handle all the debtors being sued out there. So to the extent that, allowing paraprofessionals well-trained in this area to work under the supervision of lawyers like you, perhaps that could start to eat away at a potential capacity problem we have in the state.
Sure, I think, but that makes the assumption, of course, as well, that you're going to reduce the 99% default rate by allowing paraprofessionals to be out there in the workplace. I think if and when you have consumers that are saying, I only defaulted because I didn't think I had someone could represent me, I think that would be one issue. I just don't think people are getting served, or they know that they can get representation, be it paraprofessional or otherwise, for a very small flat rate basis, or maybe in certain circumstances for free because of the counterclaims that they may have, and they're educated that they may have rights. I think that's the problem. I think whether we have paraprofessionals or not is not necessarily going to reduce the default problem, and that's the state's problem and the nation's problem right now, is getting people to respond and exercising their due process rights, and to make the creditors prove up these cases. I think that's really the issue here. And I think to answer that question would be premature, because I think if we educated it, and then you had a situation where consumers are like, oh, Abbas's law firm is too busy, they can't take us. At that point, I think that's a fair conversation. But we're not there because the consumers are not responding.
Understood. I agree that those are problems. Those two, the education problem and the service problem. That's something that we need to attack from a different angle.
And I'm Steve, and also I'm just going to jump in before Steve, because I just had one really quick comment.
Yeah, and let me say, Carolyn, we got an email from Judge Weiss that she's running late, so I think we're okay. Yeah.
Oh, okay, great. No, and maybe you have some thoughts on this, but probably not. My own thinking is with the default rate, I have, and this is a personal opinion as a lawyer, I have always felt that the 473B relief from default code in California is ridiculously complicated, and the law has become really a quagmire between 473BA and 473B, whether your lawyer screws up or you screwed up, or coming in to try and get a court to lift a default, like you said, for sewer service. So in my view, I've been trying, I'm just so busy, I'm trying to find a way to get 473A and B fixed so that consumers have a chance to get away from these defaults. It's not this complicated in other states, is it?
Carolyn, what I can tell you is I totally concur with that, in that I have one lawyer that is basically the specialist for set-asides at my law firm for those scenarios. All she does essentially is do set-asides, because she's learned the statute and the case law that surrounds it in order to be able to find the exceptions, because it is a pretty short period of time where you can exercise your set-aside rules and rights. And so it is actually quite complicated. It's not that easy.
Yeah, you have to actually prove fraud after 6 months, right? And how does a consumer prove fraud when they've been sewer served?
Yeah.
Anyway, that's more of a comment, and I would love help in trying to rewrite that rule and get it to Sacramento, but it's totally, yeah, sometimes I think that listening to all these issues, this is a problem. I don't know if a paraprofessional really is going to be able to step in and make a dent. And our laws really, California, our legislature's been great at helping out consumers. So I don't know. I don't know. But Stephen, you had some thoughts?
It was more of a comment, and it was based on the dialogue between Gregory and between Abbas, and that is, there is a hybrid model between the two suggestions that Stephen and Amos had come up with, and that is maybe this is one area where, to increase access to justice, we let paraprofessionals provide services in this field if they are under the supervision of an attorney, so that they're actually within a law firm. And I don't know if that fits what our mandate is, but to me, it seems like if we allow these services to be provided outside of a law firm without lawyers looking at these cases, we're going to create more problems than we solve. That's my observation. Thank you.
Julie, you haven't spoken yet. Julia.
Yes, Abbas, what is your opinion about that? Do you think there's really a need for some alternative working underneath an attorney that is in between a paralegal and a lawyer, or are you sufficiently, do you think, armed with legal professionals by having terrific paralegals and great associates working under you? Do you see there really being a need for a different kind of professional for you to have in your law firm to meet the consumer's needs?
I'm not against it, but I'm not sure what difference it would make. If you told me that by having paraprofessionals come and work at my law firm is going to reduce that 99% default rate, God bless you. I'm open to that, because I'm fed up of consumers having default judgments against them. But I don't see how a paraprofessional working at my law firm is going to change consumers' behavior in responding to these lawsuits. If you could show me empirical data that would actually make a change, I mean, listen, like, I'm here for consumers. I want consumers to vindicate their rights. If that will make a change, I'm open to it, and let's have that conversation. But I just don't see how that change of having paraprofessionals working in my law firm or other law firms similarly situated to mine is going to change that dynamic.
Okay, and so you do feel that the paralegals in your law firm do a considerable job, and you really are able to see the difference between what they're able to do versus an attorney. And at this point, you can't really envision how there'd be some need that exists that it would be met by a paraprofessional that you're not already able to meet.
Yeah, I think there is a material difference in what my paralegals can do and what my attorneys can do. So, I mean, for example, let's say in the screening process, an attorney spots something in the pleadings that look a little bit fishy or doesn't look quite right. They have the ability to go and do legal research on Westlaw, Lexis, and federal reporters, whatever it may be, to be able to see if there is any colorable authority to show that we may have a cause of action for that omission in the pleadings or addition in the pleadings that we think may bring about an FDCPA cause of action. Paralegal can't necessarily do that.
No, I understand that. I guess I was just trying to bring the conclusion then that you're not seeing that there is really a need in your law firm for a paraprofessional.
Unfortunately not. I mean, the only thing that would change my mind is if you could show that by the inclusion of paraprofessionals is going to increase the response rates by consumers to these lawsuits.
Okay, thank you.
Steve had a hand up, and then Amos again.
Yeah, I was just 2 quick points. Number one, Greg, in response to Carolyn's question, CCP 473 should be one of the statutes you're looking at that will require legislative change if this program goes through, because I don't have the statute in front of me, but if I recall, it's pretty clear it has to be a declaration of counsel. And whatever else paraprofessionals are, they're not attorneys. My second point, Greg, is I'm fully in favor of what you and I think Julia and Steve Hamilton are saying. And if our target audience are people that went to law school and didn't pass the bar, my understanding is they can work as law clerks in firms currently. And if the target audience are certified paralegals, they can work in law firms under the supervision of attorneys. So on the one hand, I agree with everything you conveyed. On the other hand, I just don't know. I mean, the system seems to already encapsulate those two types of people. But I'm all in favor of what you were saying, Greg, if they're going to be working under the supervision of attorneys. I just, there's an old saying, if it ain't broke, don't fix it. I'm just worried about that. So I'm curious what your thoughts are on that, Greg.
My thoughts are, it is broke. It is broke because we have 99% default rate, and we have so many unrepresented litigants in these debt collection cases right now that, and perhaps a boss is correct. It's simply an information gap problem that needs to be solved.
I mean, I'm sorry, go ahead.
Hold on.
Right.
Perhaps it's an information gap problem that needs to be solved. I do know, as admirable as it is that a boss takes every comer, I do know that there are a lot of people out there getting turned away from law firms. They're not able to get lawyers because the lawyers in those firms are doing initial assessments and they're not seeing an affirmative claim or a counterclaim. And so it's really not worth their while. And I wish they would more of them would follow a boss's model, but unfortunately that's not happening. So the other thing I would say is, I don't think that, just because somebody went to law school and graduated and didn't take the bar, it didn't mean that they either thought they couldn't pass the bar exam or they took it and failed it. I have several friends, you probably do too, who went to law school and never became lawyers. They decided to do other things. And so I don't think we should try to cast aspersions upon those people that they couldn't possibly pass the bar exam. What I'm envisioning, though, is, and I think everyone else is envisioning, is someone who can do more than a paralegal, but perhaps not as much as a lawyer. And so, and perhaps identifying some of the activities that a boss is giving to his lawyers because the paralegals are unable to do those activities, and having paraprofessionals do it may be a way of increasing capacity. So more of these law firms are not turning away clients.
Well, Greg, I hope, were you able to attend the meeting where we had the authors of the Justice Gap study speak?
I believe so, yeah.
I mean, the problem we have here is the Justice Gap study, of the 85% of unmet legal needs, 2/3 are people that didn't make any attempt to contact a lawyer, which is what a boss is saying is a knowledge gap or a education gap, and isn't the result of a shortage of providers of legal services. And that's the 99% default rate that he's talking about. The other third of the 85%, the only question that was asked is, what did you do to try to get legal help? And some said they tried to find lawyers, some said they went online, but no one was ever asked, did you try to find an attorney and you couldn't find one? So, I agree with you. There are very high numbers of pro pers in certain categories of cases, and pure debt collection's one of them. But I just don't see the data to support the idea that the affirmative claims you can't find an attorney to represent you.
Oh, if they had an affirmative claim, I'm sure that they could find an attorney to represent them.
Yeah. So.
Not every claim has an affirmative claim.
But I think, Abbas, you said 25 or 30 you caught.
In my law firm, about 25-30% of them, we managed to find some kind of counterclaim. Yeah.
So that's 75 to 70 that don't.
Yeah.
Or maybe they don't.
But then there's another 20 that we find in litigation, right?
Right, you're right.
Carolyn, do you see that other people have their hands up?
Yes. Everybody's got hands up. Okay.
And then Ira and the attendees, and if we have time, I can pull up some of this.
I didn't see the attendees, but Judge you, if you've had your hand up for a while. I'm sorry.
Amos was ahead of me, Carolyn. Amos was ahead of me.
Oh. No judicial privilege?
I'll be brief. A lot of what we've been talking about, or maybe all of it, has been about litigation and litigation claims. I'm interested in your practice. Do you also deal with pre-litigation or other than litigation? For example, when debtors are being harassed, or maybe a debt is beyond the statute. So before there's a claim or a default, where you could just write a letter and basically explain, you know, go away. You don't want to be bothering this debtor anymore. And if you do, you know, here's the things that are going to happen. So basically you could resolve it with a letter, and whether there's a counterclaim or not, you know, basically help the consumer without litigation.
Sure. So there are a category of consumers out there that actually do know that they have rights, and when they start getting telephone calls or letters, they contact us, right? Those have not usually escalated to a lawsuit at that point. And we bring their FDCPA cases, TCPA cases, whatever the case may be at that time. And that usually alleviates the lawsuit in the first place, because if we're suing them, they usually use the debt in part of the settlement, right? And so there's usually not going to be a lawsuit after the fact. But very rarely is someone contacting us that we represent that is then sued. Usually the people, and again, I'm talking in broad brush strokes here. There are always exceptions to the rule, right? But the general rule of applicability is, by the time these people have got sued, are generally people that don't know about the debt, or they've buried their head in the sand and they don't know about their rights and don't know that they could call me or my firm or people like us, and they just hope that the debt would go away, and then they go and ignore the lawsuit. Very rarely do you get an overlap on those two issues, right? And the only other thing that I would add is, in those rare circumstances when there is, and where we have engaged a debt collector pre-litigation, we are holding the weapon of attorney's fees over their heads, which is a scary concept to them, because they're like, if we're going to engage these guys, we better be right, because otherwise, if they're the prevailing party, they're going to get a bunch of fees from us. So that gives us a lot more leverage to be able to negotiate something favorable for the consumer, which a paraprofessional can never do, because they can't get attorney's fees.
Judge Yu?
Thank you. Mine is not a question for our boss, but really a comment in response to something that I heard Steve Fleischman say, which is that people who did not pass the bar could be a clerk, or paralegals could be also employed by a law firm. My sense is that paraprofessionals, there are paraprofessionals who may wish to have autonomy, have their own firm, their own business, their own sense of accomplishment, and not have to be under somebody. And if what you read about the bar exams, in some areas, some people feel that the bar exams are present different challenges for BIPOC people, that they're not really, those standardized tests are not really fair for people of color. And so if that's the case, and those people are not able to pass the bar, why are we saying they have to be a law clerk? They have to be a paralegal? Why wouldn't they have an opportunity to have their own business, their own autonomy, their own, financial freedom? That's all I wanted to say.
Do we have room to squeeze Ira in?
Yes, and I think Steve has his hand up, because I think, I unfortunately think Judge Wise is stuck in a meeting with her PJ, so I think we're going to have to try to bring her back.
Erica, I'm just going to say, I'm not trying to limit anyone's, ability to get a job and do something. I'm just saying this particular area may not be suited for this program, and there are lots of other areas we're considering, but this one, what I'm hearing from a boss is, needs to be done under the supervision of an attorney. That's all I'm saying. I'm not trying to limit anyone's ability to get a job.
I'm sorry, I didn't mean to make it personal, and I'm sorry it felt that way. I'm just wanting to make sure, maybe I'm the only person of color here, that perspective is not lost in these discussions. I mean, I'm the only committee member of color. I know there are other people here who may be of color.
Thanks, Erica. I was going to be offended.
I apologize.
Okay, do you want, Ira, it looks like he took his hand down, or maybe Linda's already given them the ability to talk. I'm not sure.
Yeah, I I think,
Okay.
can you hear me? I'm unmuted, I believe.
Yeah, we can hear you.
Thanks. Abbas, I've had two experiences that it occurs to me might be suggest a role for paraprofessionals, but I'd like to hear what you think. This is the first one's a long time ago. It's a very easy thing. I was told that that a lot of these credit card companies realize they won't be able to collect very much of what they're suing for, and they'd take a very small percentage. So I had one that was sued a client for several thousand or something like that, and we offered them 1,000, they took it. So it was a pretty easy negotiation. Now, then about 7-8 years ago, some people I know in a business got sued on a credit card, and I did the following for them for free, but it's something I think a paraprofessional could do. Filed an answer, served the kind of discovery you described, and as I guessed, they didn't respond to the discovery. And then I made a motion, the appropriate motion for terminating sanctions and all that. And they came to court and said, all right, we'll dismiss the case. And that was that. I would say that was 10, 11, 12 hours of work. And well, anyway, so do you think there's a role for paraprofessionals to do the first thing, the negotiating, and the second thing, the limited work I did in that one case?
So what you're suggesting already exists, and most companies that I know do this are in violation of a federal statute called CROA. Like debt consolidation and debt negotiation companies exist out there already, and they don't even need and they're not even called the paraprofessionals. They run kind of shops that advertise on TV, radio, and do high volume debt negotiation for people, and frankly give them bad advice in the process as well. So, but let's assume that the hypothetical paraprofessional in question is doing everything right. And in the first scenario, yes, absolutely, all creditors are going to be willing to negotiate, right? Because you only have to read the book Bad Paper to know that, well, it's a phenomenal book. And especially in this area, I really recommend it because it gives you a much more intricate understanding of the debt collection industry. But you're absolutely right, because debt collectors buy notes for pennies on the dollar. And therefore, even if they settle for a percentage of the sum owed, they're still in the black. But the question is, in negotiating $1,000 from a $7,000 debt, do the best we possibly could for the consumer under those set of facts? And I don't know the set of facts. Did we miss any counterclaims? Did you negotiate that it comes off the credit report? It's not something that is mandated under law, but I always try and negotiate it. And I'm not sure that a less sophisticated paraprofessional has the knowledge and the know-how to work those nuances. Maybe we could have got the debtor out of this for zero. Maybe could have put money in their pocket. Are those nuances being fulfilled? And my suspicion is, if a paraprofessional was negotiating that consumer debt, even though they thought on the surface they did a good job negotiating a $7,000 debt for $1,000, it may not be as good as what I could have done. I'm not saying I could have, but I'm saying I would have had different considerations in those negotiations. The second hypothetical is a business debt. So we're now not in the world of consumer defaults right now. We're in a business debt.
It was a personal debt that I mentioned they owned a business. That's how I knew them. They were the restaurant down the street from my office, but it was personal debt.
Well, I think, right. I mean, I assume, Mrs. Spiro, you're a lawyer, right?
Yes.
Okay, so you went through the discovery process, brought a motion to compel, and you did exactly what I described in my introduction. You went through the litigation process as a sophisticated lawyer and papered them, and they didn't want to deal with it. And they did exactly what I said about 20% of the time they would do, is when you engage in heavy litigation, they're not equipped on the other side as debt collectors.
It wasn't very heavy. It was,
I'm sorry?
it wasn't very heavy. I served discovery and I made one motion. So it seems to me that a lot of people who are not very, that a paraprofessional could do that.
So a paraprofessional can go do legal research and do a table and do like authorities and bring a motion the way a lawyer.
Yes, that's a very simple motion. Yes, and there's forms for it.
Well, maybe. I mean, I think that's where we differ in opinions. Sir.
Okay.
Oh my goodness, I had the, oh, Leah, I was wondering, kind of bringing up those high volume debt negotiation companies. Do they ever get, and maybe Amos might know this too, is there ever any complaint, their data on the amount of complaints, consumer complaints that are brought to the state bar or to the Department of Consumer Affairs about the unfair treatment of those entities that are trying to help people? Because I know some of those really have, really are problematic.
Not that I know of. I asked Kim Kirchmeyer with DCA. I did reach out to her this week because I was curious about DCA's role as a consumer protection agency, and she sent me some stuff, but we don't handle that at the state bar. It is 12:20, Carolyn. We got a couple. Steve has his hand up again. There's there's a couple of things I would like to say. I still, unfortunately, don't know that we have a really solid handle just on the steps that need to be taken to do the work. I'm pretty clear on discovery, and I'm clear on the screening and need to identify if there are certain defenses or affirmative claims that can be made. But I'm not exactly clear on, once that process is completed, let's say there are no smoking guns for the defendant, what is the actual work involved of responding to whatever the creditor has filed in Superior Court? Maybe the rest of you all are, but I feel like we haven't quite gotten there. So that's one thing I'd like to say. And then I do have some interesting federal court stats if we want to. So we have 9 minutes. So it's obviously, and you're up to you as the chair, Carolyn, but.
I think maybe we do have another session, right, of our group coming up.
Yep.
And maybe, because I don't think it's that easy of a question. I think it's a class that Abbas teaches to answer that question. So yeah, maybe I'd like to hear from her honor. We have a new joining.
She did join us. I'm sorry, I didn't see that.
That's okay. It was just a minute or two ago. It wasn't that long. I really do apologize to everyone for the delay. There was a meeting I was having a very difficult time getting off of. In fact, it's still going, but I thought I could disappear for the last couple of minutes of it. I'm happy to approach this however you want. I know you don't have a lot of time left, so whatever I could offer up that would be the most useful.
I'm just going to ask if I could ask a question. Welcome and thank you. I know you're really busy, but we've heard that, and I think the Justice Gap study did show that consumers in debt litigation is one of the #1 issues that is facing and plaguing our courts. And we've been spending, 40 minutes to a long time here and 3 or 4 sessions over the year trying to grapple with how can a paraprofessional come into court or represent people out of court in a way that helps them walk into court with a better presentation. What's your experience in that area? What do you think about how someone can stand up to these big, massive entities and make a difference?
There's a lot packed in there. I will tell you that my current assignment right now, so I'm our acting supervisor for civil, and we've got a pretty big civil unit here in Alameda County. And we've handled collections in different ways in the past. We've had them with one dedicated judge. We've had them farmed out to a number of judges. I handled them for some period of time, and then I've handled an ancillary assignment that still addresses that. So I've seen a fair amount of it over the years. I will tell you in my experience that the vast majority of these kinds of limited collections cases that we see, the people are self-represented, and the vast majority of them end up in default. Now, whether they end up in default because they really weren't ever properly served, or they can't afford counsel, or it's hard to know exactly what the situation is there. But I did mention, and I was having a little back and forth in getting ready to come on to this meeting, that I know that one of the things that you're grappling with is the idea of how to deal with predatory lenders, whether that's a carve out. And I will say there is a lot of overlap, I think, between this practice and the predatory lending that occurs. So I'm not opining on what you should do about that, but just to say it's often difficult to know on a case-by-case basis whether there's a predatory lending problem until you get all the way to, especially in the default scenario that we're frequently seeing, until we're getting to the point where it's a prove up, where we're actually looking at the underlying documents, because it's then for the first time that a judge may really pay attention and see, oh, there's a 64% interest rate on this case. That looks troubling, right? I mean, those kinds of things, or you can see that it's a plaintiff that's coming around over and over again. And I think one of the things that you might want to think about, if there's going to be an aspect of this that would be covered by some sort of a paraprofessional, is to think about, a lot of these cases really would be small claims matters where nobody would be represented by counsel, but for the fact that the entity that is seeking to enforce the debt is a company or corporation that can't bring this in a small claims action. So you might want to think about a dollar limit, whether that dollar limit is aligned with what would otherwise be in small claims, or you think about something else accordingly. Something else that, well, I don't want to talk for too long. I want to be sure I'm focused on what you're interested in.
Oh, I have my hand up, but other folks, questions? What is the volume in Alameda County compared to other counties? Do you have thoughts on that? Have you looked at that in terms of consumer debt cases?
I don't know that I have a good sense. I'm not even sure where we would get that information in terms of getting really credible information about how we compare, and whether you're looking at just raw data in terms of case numbers versus a per capita for the number of people we have in our county or something like that. I mean, we definitely have thousands and thousands of these kinds of limited collections matters. And, I would have some concerns personally about thinking about the kinds of cases that have implications that are not in limited collections matters, right? So collections matters that are in the hundreds of thousands of dollars, and and judgments that are associated with them. I don't think that inherently means that couldn't be handled by a paraprofessional, but I think there are other concerns that you would want to think about in terms of training and otherwise. But in terms of the truly limited cases, you rarely see them that are under about $1,000 or $2,000, because I don't know that it makes sense for people to bring them for what it costs to do it. But between there and 10 grand, I mean, we see a ton of them.
We really haven't gone to this issue yet, but I was grappling in my mind while Abbas was talking, but I've always been interested in what the self-help courts do more, because I know people go there and they say, I can just hand you the forms, I can't give you legal advice. Is there a way we can help what does Alameda County do with regard to self-help forms and the paper forms, the judicial counsel forms that we have, and that kind of thing?
Caroline, I'm just going to jump in. I'm going to jump in. Hi, Noelle.
Hi.
Nice and Caroline, Caroline's probably told you this already, but your audio, there's a lot of some kind of, it sounds like you're in an echo chamber, so it's actually difficult to hear you.
Oh, I've got a new computer, so I'm sorry about that.
No, that's okay. So Noelle, correct me if I'm wrong, since I haven't been there for a couple of years, but I mean, I think it's the same as the self-help centers everywhere. Yes, they'll help with forms and all to a certain degree, but they simply cannot give legal advice. And so the help that's given is quite limited.
Yes, and yes. And the meeting that kept me from getting on this call earlier is we have serious budgetary problems right now in our court. I mean, I just can't even, it is beyond what it's ever been before, even if the court gets the money that they think it's going to get, which the legislature is suggesting is restoring us because of our lack of fees and other things that we're taking in. We're really, really in a bad place and trying to figure out what to do about that. It was already hard for people to sometimes get in and get assistance from self-help. I don't think that we should not expect that that's going to get better anytime soon here. And the truth is, the problem is that if someone is already from an access standpoint, and whether it's a language barrier or whether it's an economic barrier or it's an education barrier, if they're already intimidated by this process, being able to interact with our system, to know who to call in self-help, to know how to respond, how to work through those forms if they can, and not throw up their hands, I think is a challenge. And it's only as good as the amount of money and access people have even to that. And so I don't think that we have that already, and we still have thousands of cases, and the vast majority of them are in default. And like I said, I don't think that's going to get better.
Carolyn,
Yeah,
I'm going to judge you. Yeah, and then.
Thanks. I just want to add quickly, Carolyn, in Santa Clara County pre-pandemic, people were lining up at 7:30 in the morning all around the building to try to get into the self-help center. Since the pandemic, services are limited, and mostly it's concentrating on DV and restraining orders. So it's not a place where people will be able to receive the assistance that they need in the numbers that are required.
Judge Wise, I want to be conscious of everyone's time, and I so appreciate you scrambling to hop on. And we really do, I think, need to hear from you, because what it has been difficult for us is to just understand sort of the nature of the proceeding, what happens in these cases. So I think we have a good handle on some of the more complex issues that can arise, but maybe not such a good handle on sort of your bread and butter collections case and what it looks like from a court perspective. So perhaps we can work together offline and see if you may be available for our next meeting, which is not for 2 weeks, it's more reasonable notice period. And
when it is?
Yeah, I will email you. It's March 25th. And if not, perhaps another meeting. But I do want to appreciate you jumping on and just be cognizant of everybody's time.
Can you please, what time on the 25th is the meeting?
I believe it is, sorry.
I have it as 10 to 12.
Which I suspect may not work. Noelle, are you in, do you know if you have calendars that morning?
So I have Law in Motion every Thursday. It's usually done by 10:30 or 11. And today would have been perfect. I would have been able to join you for a good amount of time. I will tell you that the budget issues right now, coming up regularly. And so barring something unexpected like this, I would have no problem making it for at least some of that meeting on the latter side.
All right, it is actually 10:30 to 12:30.
Oh, sorry, I wrote it down wrong then.
It's okay.
I'll put it in my calendar now.
All right. Thank you, Abbas. And it sounds like Carolyn will probably need to, we might need to figure out how to schedule another meeting to give the group time to just talk amongst themselves, because we weren't able to do that today. And I think we're going to have a heavy presenter calendar next time. But perhaps we can work on that, Carolyn. Thank you.
It was nice seeing all of you. I'm sorry again for my delay.
Oh,
thank you for jumping in last minute.
All right.
Boss.
And thank you a lot, Abbas. Okay, bye-bye.
Hi, everyone.